So why are we here? Why are we here? You heard the state get up and tell you this is an open and shut case, right? There's DNA, ballistics, GPS evidence. The state's certainly convinced. That's all very important. So why are we here? You may already have your mind made up. I know Detective Richard Spittler with the Austin Police Department certainly did, just hours into his investigation. So why are we here? We are here because the state's opinion of what the evidence is and the Austin Police Department's opinion of what the evidence is isn't important. You are the most important people in this room. It is your opinion of the evidence that we are here for. That's why we're here. Reasonable doubt. I want to talk to you about reasonable doubt. Reasonable doubt is doubt that is supported.
Jeff, he's making arguments about the weight of the evidence. He's not giving a roadmap.
Provide an opening statement what the evidence would show. What our statements to that.
I plan to, Your Honor. Reasonable doubt is doubt that is supported by reason and common sense. And I expect at the end of this trial that we will be talking about doubt, what that is. But for purposes of my remarks to you this morning, I want to talk to you about reason and common sense. Now, reason.
Because once again, that's not a roadmap for evidence. That's argument.
Objection sustained.
Judgment we approach?
Yes.
Now, the state just discussed with you what you will see, what you will hear about, what you will hear throughout the course of this trial. But I want to talk to you about what you didn't hear about. What you didn't hear about. You didn't hear that not one witness saw Kaitlin Armstrong allegedly commit this murder. Not one, because there isn't one. You didn't hear.
Because I'm going to object again. He's supposed to be presenting the evidence open that he's going to show, not evidence that he's not going to show. Once again, this is argument.
If the implication from the argument is that the evidence that you open statement, that you stated in open statement, states one thing, and he's pointing out what that evidence does not show, that would be permissible. But we were limited to that and not argument as to the facts of the case or why it was not amount to the burden of proof that we need in this instance.
Thank you, Your Honor. You won't hear, and you didn't hear, about any camera footage showing Kaitlin Armstrong at the scene of this shooting, despite there being tons of cameras in the area. And you heard opening statements about all the cameras that were in the immediate vicinity of the scene of that shooting. Not one captures Kaitlin Armstrong at that scene, because there isn't any. You did not hear about any direct evidence showing Kaitlin Armstrong is responsible for this crime, because there isn't any. Now, you will hear at the time Kaitlin left Austin to go to New York and then to Costa Rica, she would have no reason to know about anyone that was present in this case. That the Austin Police Department told her she was free to go. She was free to go. That's what you will hear. You will hear that Kate is passionate about traveling. She's passionate about yoga. And you're going to hear that she was totally comfortable traveling to far-off locations that intrigued her at the drop of a hat, on a moment's notice. That's what you'll hear. And you'll hear in the days following the shooting, weird things were happening to Kate at her home, documented things, things that would cause a reasonable person to fear for their safety, and that ultimately led to her decision to leave Austin. And you're going to hear people among us who are weak to begin with, who are troubled to begin with, who are damaged to begin with, are more likely to fall into that kind of state of reaction, an attempt to retreat. So let's talk about some of the witnesses that you may hear about over the course of this trial. Detective Richard Spitler. Now, he's the detective who, prior to the investigation of this case, had never served as a lead detective in a murder investigation. Not one. But I'm sure he did very well on his exams. You're also going to hear from Detective Katie Conn. Now, she's the detective that will tell you she's never met a defendant she couldn't crack in an interrogation, even if they invoked their rights multiple times throughout the conversation. Asked for their lawyer multiple times throughout the conversation. Asked to leave multiple times throughout the conversation. Now, the state is going to attempt to tie Miss Armstrong to this shooting through purported forensic science. And you'll hear from the DNA analysts that examined some items that were collected in this case. And you will hear from a ballistic technician who will tell you he eyeballed some shell casings that were submitted in this case and determined that they were not inconsistent with a firearm that was taken from the home of Kate and Colin. But you will also hear from experts. And I want you to listen when those experts tell you DNA reporting can mean very little. And ballistic science isn't a science at all. And it's not highly regarded by members of the general scientific community.
I'm going to object to that. There's no evidence that it's not highly regarded by the general science community just because you can find one or two people to say that.
Judge, these are opening remarks. This is what we expect the evidence to show. This is proper argument. Thank you. Before that objection was overruled, we were talking about ballistic science and how that is far from the gold standard that you see it depicted as on TV. Now, the states and the officers with the Austin Police Department and the scientists that they employed, they were so desperate to keep Kaitlin Armstrong in their crosshairs that they had tunnel vision and they jumped to conclusions. And at the end of this evidence, you will be left with the conclusion that the state's purported forensic science is inaccurate, is unreliable, and unscientific. Now, words and phrases have the meaning that we give them. Words and phrases are meaningless unless jurors like you draw a hard line in the sand. Phrases like presumption of innocence.
Once again, he's making an argument.
Proof beyond any reasonable doubt.
Judge, once again, he's making an argument.
Judge, this is the burden of proof. If the state is apprehensive about the jury hearing about
I'm apprehensive about him not giving a roadmap and giving an argument at open statement. That's what I'm apprehensive about.
You said 4 words, I don't know where you're going from there, so I'll allow you to finish your sentence to see if it is part of the statement.
Thank you, Your Honor. I appreciate it. must approach the task of your evaluation of the evidence with the willingness to think that which I know as a father, as a person, as a human, know to be the most difficult words to say. I don't know. I don't know. And I want you to approach that task.
Judge, once again, he's talking about how the jury weighs the evidence. He's not talking about the foundation of what he's laying and what he expects to prove.
Judge, this is appropriate argument. Your Honor,
This is opening statement.
I didn't hear the first
I
round.
just said this is opening statement, I haven't made a ruling, but I would ask again that you could find your remarks to the appropriate statements for this juncture of the trial.
Thank you, Your Honor. I don't know. At the end of the evidence, that is your conclusion. We don't know. The appropriate verdict is not guilty. And as you approach that jury room, if that is your conclusion, we don't know, not for sure, then the appropriate verdict is not guilty. The state has a job to do. We have a job to do. And you stand between us. And we stand
Judge, that's not opening statement.
Objection sustained.
with Kaitlin Armstrong, a woman who is trapped in a nightmare of circumstantial evidence.
That's not opening statement.
Judge,
That's
I'm
argument.
discussing the evidence, and that it
You're
is
discussing her
circumstantial.
state of mind. That's not
Objection to
evidence.
the statement is sustained.
Okay. We have an awesome responsibility. Yours is more awesome. And at the end of the evidence, you will be left with the conclusion that the state has fallen short of the incredibly high burden that they have willingly accepted in choosing to accuse this woman of a very serious crime. You had your chance. You could have been excused on Monday, but
Judge,
you,
that's not opening statement.
Objection sustained.
but you told us you'd be fair.
That's the same line of question. It's not opening statement.
Are we concluding this case?
I'm trying to wrap it up, Your Honor.
And you're not doing opening statement.
Let's wrap it up appropriately as far as what the evidence from your portion of the trial or what you intend to show or think will be shown to the jury.
I'm trying to get there, Your Honor, despite
Without
interruptions.
argument. Let's do it
Yes.
without argument.
Yes, ma'am. Thank you, Your Honor. At the end of this case, your responsibility is more awesome. And you will have the conclusion that the state has fallen short of its burden.
Judge, once again, every time you sustain, he gets up and says the same thing. He's making arguments about how they weigh the evidence at the end of the trial.
Judge.
That's not opening statement.
It is the burden of proof, Your Honor, that the jury has in this case. If the state's apprehensive about the burden of proof that they've accepted,
There's a time and place to talk about the burden of proof, and it's not opening statement.
Let me stop both. If there are no further statements about what the evidence is going to show, then we can move on to the next portion of the trial. So we've heard that statement that you've made a few times now, so I would ask you if there's nothing else about the evidence.
there is, Your Honor.
Okay.
We trusted you then. And we trust that at the conclusion of this trial, when you look at the evidence, you will come to a just verdict. And that just verdict, we trust, will be a verdict of not guilty.